Okay, good afternoon, everyone. Welcome to today's guest session as part of the course on comparative constitutional adjudication. And we are delighted to welcome Dr. Kristina Trykhlib, who is Associate Professor at the Department of Theory of Law of the Yaroslav Mudry National Law University in Kharkiv, Ukraine. And we have, I think, a very exciting discussion and important discussion ahead of us on constitutional adjudication in Ukraine. Let me also mention that this event, in addition to being part of the course at the Jindal Global Law School, is part of the project Talking Courts, which runs in collaboration with the Jindal Global Law School as an initiative to open up the discussion on courts and judges to broader audiences and to establish networks and collaborations not only between academics but also academics and practitioners. Even though some of these sessions are a little bit more academic, we have a wide network also, including court practitioners whom we send the outputs, the results of these discussions. So I think that can also be an interesting dimension to this session. And of course, as the poster and the information about the session have indicated, Dr. Trykhlib has also sent a few recommended readings, including one of her many publications, many articles that she has contributed to understanding also for a global audience the debate on constitutionalism in Ukraine, and I think just that article offers a lot of possibilities for questions and debates, including on concepts that go well beyond the specific jurisdictional debates in relation to Ukraine. Now, Dr. Trykhlib has also had numerous scholarships and research stays at different institutions, including the Polish Academy of Sciences, the University of Innsbruck, the Jagiellonian University in Krakow. So I think we have really someone who can provide authoritative readings of what is happening with this particular constitutional court in the broader context of perhaps also constitutional but also political developments in Ukraine at the present time. So I understand that Dr. Trykhlib will speak for about 40 minutes, and then we will have some space for questions and discussion. So please do not hesitate to think about questions, issues that you would like to find out more about. And also, because the course is titled, for those who are students of the course, comparative constitutional adjudication, also references and interactions with other jurisdictions are very much welcome. So I think without further ado, Kristina, please, the floor is yours. Thank you so much for accepting this invitation and for joining us during busy teaching period for yourself. So we look forward to your talk and the discussion.
Thank you, dear Max. First of all, I would like to thank you for inviting me to participate today with you. It's a quite new experience for me to give a lecture to students from India. So I realized that the topic of constitutional adjudication in Ukraine might be quite exotic for you, but I hope that it will be interesting, and in case of any questions, you will have opportunity to ask me. So first of all, I would like to say that the Constitutional Court of Ukraine, today we will discuss briefly the main functions of the Constitutional Court of Ukraine, the status of judges of the court, the grounds and procedure for applications and considerations of cases, and all these questions, they are regulated basically by three main laws. First of all, it's the Constitution of Ukraine in chapter 12. This chapter is dedicated to the Constitutional Court of Ukraine. The second very important law is the Special Law of Ukraine on the Constitutional Court of Ukraine, and also we have the rules of procedure and the regulations on the Constitutional Court of Ukraine Secretariat. These acts, they regulate mostly organizational and administrative issues. Just to know that the Constitutional Court of Ukraine is located in Kyiv, in the capital of Ukraine, and it started its operation in October in 1996, and the first constitutional applications were accepted in January 1997. And this how the Constitutional Court of Ukraine looks like. The building on the Constitutional Court, it is situated in the very heart of the capital of Kyiv. This is the picture of the court outside, and this is a picture of the court inside. Actually, the court room of court proceedings, and the judges of Constitutional Court of Ukraine. So, as I mentioned, let's start with the main principles of activity of the Constitutional Court of Ukraine. So, according to the law of Ukraine on the Constitutional Court, the main principles of court's activity are rule of law, independence, collegiality, publicity, openness, completeness and comprehensiveness of the trial, and reasonableness and bindingness of decisions and conclusions of the court. So the Constitutional Court of Ukraine consists of 18 judges, and the term of office is 9 years without the right to be reappointed. The selection of candidates for the position of a judge of the Constitutional Court of Ukraine is carried out on a competitive basis in accordance with the legislation. So, as I mentioned, we have 18 judges. 6 judges are appointed by President of Ukraine. 6 judges are appointed by the Verkhovna Rada of Ukraine, it's the Parliament of Ukraine, and the 6 judges are appointed by the Congress of Judges of Ukraine. And the chairman of the Constitutional Court is elected by the judges of the court from among their members at a special plenary session by secret ballot for only 1 3-year term. So what are the requirements for the candidates for the post of a judge of the Constitutional Court of Ukraine? So the first one, it's a citizenship of Ukraine, also proficiency in the state language. We have one state language, and it's Ukrainian language. Attainment of at least 40 years of age on the day of appointment, higher legal education, experience of professional activity in the field of law for at least 15 years, high moral qualities, be a lawyer with a recognized level of competence, and not to be a member of any political parties, trade unions, as well as judge of the Constitutional Court may not hold any other paid positions or perform other paid work except scientific teaching or creative activity. So as you see, I highlighted the high such requirements for the position of the judge as high moral qualities and be a lawyer with a recognized level of competence, because I suggest that the evaluation of these criteria will be a little bit can be a little bit complicated because it refers needs some additional evaluative criteria. So. And actually, according to the Article 149 of the Constitution of Ukraine, judges, they also enjoy judicial immunity. They are independent and inviolable in their activities. So what exactly are these guarantees? Firstly, the first guarantee is that without the consent of the Constitutional Court of Ukraine, a judge of the Constitutional Court may not be detained or kept in custody or under arrest until the court delivers a guilty verdict, with the exception of the judge's detention during or immediately after committing a serious or especially serious crime. As a second, a judge of the Constitutional Court may not be held accountable for voting in connection with the adoption of decisions by the court and its rendering of opinions, with the exception of committing a crime or a disciplinary offense. And the state ensures also personal safety for the judge of the Constitutional Court as well as for his or her family members. The powers of a judge and the guarantees of his activity cannot be limited in the event of the introduction of martial law or a state of emergency, or in Ukraine, in the whole territory of Ukraine, or in some of the regions. So again, as in Ukraine, the martial law was introduced, as you know, nevertheless, the Constitutional Court of Ukraine acts, so it works. It considers constitutional applications despite such a difficult time. So what are the main powers, empowerments of the Constitutional Court? The first one is the resolution of issues of compliance with the Constitution of Ukraine, of laws and other legal acts of the Parliament, acts of the President of Ukraine, acts of the Cabinet of Ministers of Ukraine, the government, and legal acts of the Verkhovna Rada of the Autonomous Republic of Crimea. So here I'd like to mention that de jure, the territory of the Autonomous Republic of Crimea belongs to Ukraine. So, but Crimea has a special status, a special autonomous status according to the Constitution of Ukraine. That is why we have in Autonomous Republic of Crimea, there is also the Verkhovna Rada, so the so-called parliament, the highest legislative authority of this republic. Also, so it's the first main point. The second task and power function, it's official, and it's one of the most important function of the Constitutional Court. It is official interpretation of the Constitution of Ukraine, because only the Constitutional Court has the right to officially interpret the Constitution of Ukraine. Thirdly, Constitutional Court of Ukraine provides opinions on the conformity of international treaties of Ukraine with the Constitution of Ukraine at the request of the President of Ukraine, or at least 35 MPs, or at the request of the Cabinet of Ministers, that is on the request of the government. Also, the Constitutional Court provides opinions on the constitutionality of issues proposed for submission to the all-Ukrainian referendum on a people's initiative, or at the request of the President of Ukraine, or at least 45 people's deputies of Ukraine. Also, the court provides an opinion on the observance of the constitutional procedure of investigation and consideration of the case on the removal of the President of Ukraine from his office by impeachment at the request of the Parliament. Also, the Constitutional Court resolves the issues on conformity with the Constitution of the law of Ukraine upon a constitutional complaint of a person who believes that the law of Ukraine applied in the final court decision, in his case, contradicts the Constitution of Ukraine. Questions about the conformity of the laws of Ukraine and other acts with the Constitution, as well as efficient interpretation of the Constitution, they are considered according to the constitutional submission of the President of Ukraine, at least 45 MPs, so the members of Parliament, the Supreme Court, Ukrainian Parliament, Commissioner for Human Rights or Ombudsman, or the Verkhovna Rada of the Autonomous Republic of Crimea. So these these are the main subjects who may appeal, who may apply constitutional application submission to the Constitutional Court of Ukraine. Also, very important point that, as I mentioned, the main function of the Constitutional Court is the interpretation of Constitution, but not the laws of Ukraine. So previously, the Constitutional Court of Ukraine also had such function as the interpretation of not only Constitution, but also the laws of Ukraine, but it was cancelled, replaced, and nowadays the main function is only the official interpretation of the Constitution of Ukraine. Also, it was mentioning that decisions and opinions adopted by the Constitutional Court of Ukraine are binding, final, and cannot be appealed. So actually, the decisions of Constitutional Court they are generally binding for everybody, for president, for parliament, for cabinet of ministers, of course, for private persons, and these decisions may not be appealed. Laws and other acts by decision of the Constitutional Court of Ukraine are declared unconstitutional in whole or in part if they do not comply with the Constitution, or if the procedure for their review, adoption, or entry into force established by Constitution has been violated. So the Constitutional Court decides a question on conformity with Constitution, I would say the conformity with formal requirements, so the procedure, as well as substantive requirements, so the compliance with the very essence, with the content of Constitution, as well as the observance with procedure. So procedural questions plus material evaluation of material content. And also material or moral damage caused to individuals or legal entities by acts and actions recognized as unconstitutional shall be compensated by the state in accordance with the procedure established by the law. So the law on the Constitutional Court of Ukraine also prescribes the procedure for compensation for damages in case of unconstitutional decisions, so the decisions declared unconstitutional by the Constitutional Court. On the 6th June in 2022, the European Commission published an opinion in which it recommended granting Ukraine the status of a candidate for the European Union, and as you know, on June 23rd, the European Council granted and approved this decision. However, having said yes, the European Union has set several conditions. If not fulfilled, Ukraine may lose this status. So the first two of them, they concern judicial reform. In particular, in the last conclusion by European Commission, there is a direct emphasis on the necessity to reform the Constitutional Court. So the reform of Constitutional Court is the first #1 priority for the European Union, namely it is about the adoption and implementation of legislative changes regarding the procedure for the selection of judges of the Constitutional Court. So the European Commission and the European Union many times emphasized that the main point here is the creation, the elaboration of a transparent procedure for the selection of judges, appointment of judges for the Constitutional Court, and of course with a check of integrity and professional level in accordance with the recommendations of the Venice Commission. And in this regard, the Venice Commission recommended Ukraine to introduce a transparent procedure for the selection of judges with a special integrity checks and involvement of foreign and public experts. And as I previously mentioned, when we were discussing the requirements for the position of a judge of the Constitutional Court, there were two very interesting requirements as high moral qualities, yeah, so and the high level of competence. And actually, for this purpose, to evaluate the high moral quality of the judges and as well as their competence, the Venice Commission recommended to involve in the commission special foreign experts and public international experts. According to the recommendations presented by Venice Commission, Ukrainian Parliament changed the law on the Constitutional Court, and the latest change were introduced at the end of July 2023. And from now, the selection of candidates for the position of judge of the Constitutional Court is carried out exclusively on a competitive basis, including the persons appointed by the President of Ukraine, the Parliament, and the Congress of Judges of Ukraine by a specially created competitive commission. So it means that the President, the Congress of Judges, as well as the Parliament, they must conduct a very transparent competition. And for this purpose, actually, a special advisory body, namely the advisory group of experts, was created. This competitive commission actually consists of, it is formed by the President of Ukraine, but also it gathers recognized lawyers and scientists with recognized level of competence. So this is not a political authority, this is not a political body. The very essence and the main idea of competitive commission, of the creation of this authority, was to actually to balance this, not to balance, but even to exclude the political component from the competition, and from the competition to the position of a judge for the Constitutional Court, because Constitutional Court must be depoliticized. As I mentioned, the law of Ukraine introduced the so-called advisory group of experts, and this is an important element and a novelty of the competitive selection of the position of the judge. And also, I wrote the link to the official site of the Constitutional Court, namely to this advisory group. It is available in English, so if you are interested, you may figure out details of function or not function, but creation of this commission. I must say that this commission actually it is in the process of creation. So the process of creation is not for now has not been finished. So for now, we do not know the composition of this advisory group of experts. Yeah, so we don't know who, for instance, from the international expert will be in this commission. We are in the process of creation of this advisory group, because, as I said, it's a quite new element. Organ. The advisory group of experts is formed with the aim of assisting the subjects of appointment of judges of the Constitutional Court in evaluating the moral qualities and, as I mentioned, the level of competence in the field of law of candidates for the position of a judge of the Constitutional Court of Ukraine. So what about the composition of this advisory board? Because, as you see, it is a quite key organ. It consists of 6 members who are appointed for a term of 3 years and participate in its work on a voluntary basis, so for free, pro bono. A person cannot serve as a member of the advisory group for more than 2 consecutive terms. So, and what are the requirements, formal requirements for the member of this advisory council? First of all, it's enrichment of the age of 45 on the date of appointment. Also, it's possession of higher legal education with a master's degree obtained in Ukraine or abroad, experience of professional activity in the field of law for at least 20 years, high moral qualities, be a lawyer with a recognized level of competence, and of course political neutrality, what is also very important. So it means that any political members from any political parties or any, I don't know, political government and so on may not be included in this commission. So only a politically neutral person may be a member of this advisory group of experts. Who may not be a person who may not be a member of this advisory group? First of all, if a member holds, as I mentioned, a position in any political party or participates in political activities. Also, if person is elected to an elected position in a state authority or a local self-government body, has a representative mandate. So it means that, for example, MPs may not be subject of this group. Also, a person who recognized as incapable or whose civil legal capacity to act was limited by court decision, as well as from this group exclude the judges, prosecutors, investigators, civil servants, and other public officials may be also excluded. And the very important point, actually, what about the composition of the advisory group? One person, as we know, we have 6 members. So one person is appointed by the President of Ukraine, one person by the Parliament, one person by the Congress of Judges of Ukraine, one person is appointed by the National Academy of Legal Sciences of Ukraine, one person is appointed by the Congress of Representatives of Legal Higher Education Institutions and Scientific Institutions, and one person is appointed by the Assembly of Representatives of NGOs, which during the last 5 years have been active in the field of constitutional reform and or the rule of law, as well as the protection of human rights and prevention or counteraction of corruption. So it should be a specific NGO with a specific aim of functioning. During the transitional period, namely 6 years, the advisory group includes one person appointed by president, one by parliament, one by judges, and attention, here we have, because actually nowadays we are in the process of this transitional period, so it is important, because now we have this procedure, we have the process of creation this advisory board, and very important that for the period of transitional for 6 years, for the time of transition, one person will be appointed by the Cabinet of Ministers of Ukraine on the proposal of the Venice Commission, and 2 persons will be appointed also by the Cabinet of Ministers, so by government, on the proposals of international and foreign organizations who actually, as we mentioned earlier, who are involved in the activities protecting human rights in the field of constitutional reform, strengthening the rule of law, and so on and so forth. So, as you see, actually we have 50-50. So we have 3 persons appointed by, we could say, political authorities, by president, parliament, and government, and we have also 3 persons appointed by by the government, but on the proposal of the Venice Commission, as well as international and foreign organizations. So we see the involvement of international, independent, of course, independent, non-political, international and foreign organization, as well as internationally recognized, well-known legal expert from Venice Commission. Advisory group of experts is considered formed, provided that at least 4 of its members are appointed. And during this transitional period of 6 years, advisory group takes decisions by at least 4 votes from 6, of which at least 2 are proposed by international organizations or the Venice Commission. So, and the next point, situation that could arise potentially, what should we do in case if due to the same number of votes for and against? So how should we what kind of votes will be the decisive one? So the advisory group, in this situation, if we have 50-50, for instance, as a result of voting, then the second vote should be held. In case if after the second vote, after the revoting, again, we will obtain equal number of votes for and against, the votes of 3 members of the advisory group of experts, at least 2 of whom are proposed by international organizations or the Venice Commission, are decisive. So this actually was the key point, a key point for disputes between the European Union, the European Commission, and our government, our political establishment, because we actually previously just to save our to preserve our national sovereignty, we tend to save the decisive voices for Ukrainian, so for not for international experts, but for subject persons who are appointed by president or by government, so by Ukrainian citizens, but not by foreign experts. But finally, because it was, as I mentioned, it was one of the main requirements to grant this, not to grant the status for the candidate for European Union, but to move on our work and because for now we want to at least to the end of this year to start the negotiation procedure for joining the European Union, and it was one of the main requirements for start these negotiations with the European Union to actually to give this decisive voice for international experts from Venice Commission and other international organizations, at least during the transition period for 6 years. So, but for now, we are in the process of creation this advisory board, so we have not known who will be presented and appointed from international community, scientific community. Meetings of the advisory group are held openly except for cases provided by the law. The body that provides organizational support for the activities of the Constitutional Court ensures the broadcasting of the meetings of the advisory group in real time on the official website of the court, and I think that this is very important to make these hearings be publicly available, and it also one of the feature of this transparency procedure. The advisory group makes a decision by at least 4 votes, except for cases provided by the law. So what are the powers of the advisory group? First of all, except of the main function of the advisory group, of course, is the assessment of moral qualities and the level of professional competence in the field of law of candidates. But also the advisory group consider, verify and analyze different documents of candidates for the position of a judge. Also, it conducts interview with candidates. And so we see that it's a quite deep involvement and evaluation procedure with a deep comprehensive analysis of declarations applied by judges and other documents, not only interview, but also the analysis of different of CVs, different, I would say, reputation, actions of judge and his or her history and experience, work experience, and participation, I don't know, in any organizations, civil organizations or political parties, business, perhaps business, previous business activity, and so on. The decision of the advisory group in the process of competitive selection of candidates can be challenged in court, what is also very important. So it doesn't mean that this decision is like the last instance without any appellation. So these decisions may be challenged to the court. Also, with regard to all candidates admitted to competitive selection, a special check is carried out in accordance with the procedure provided by the law of Ukraine on prevention of corruption. So it's also worth mentioning that every person who, not only for the post of the judge of the Constitutional Court, but I would say in general for state authorities, any post for state position, I would say, must be checked or must be specially verified according to the law of Ukraine on prevention of corruption. So a special check, integrity check, must be conducted for the judges of the Constitutional Court of Ukraine as well. So, concerning the how to verify, how actually to assess high moral qualities. So we have some criterion listed in the law of Ukraine on the Constitutional Court. Of course, they could be also, they are not so, I would say, definite, but anyway, we have some at least points that must be evaluated, verified. So it's the integrity of the applicant, and actually the applicant for the position of a judge for the Constitutional Court must also file different declarations and as well as declarations of relative ties and declarations of asset on the possession of asset. Also, it is absence of reasonable doubts regarding the legality of sources of origin of the candidate's property. So in case of any doubts, the candidate must prove the legal basis, so the legality for the obtainance of his or her property. Also, its compliance with the standard of living of the candidate or the family of candidate with declared income. So it doesn't mean that it's only like formal verification of written declarations, but also the members of advisory board, they are empowered to they are empowered to verify if actually if the judge, not the judge, but the candidate for the post of the judge, how the lifestyle looks like of such a candidate. So it must be also verified if actually the information presented in declaration corresponds to the real life and to the real income of the candidate. So it's a compliance of the candidate lifestyle with his status. Again, it's a quite broad. It could be also quite vague, but at least we have some kind of guidelines. The next point is the verification or compliance with the recognized level of competence in the field of law. And of course, it's the verification of knowledge, and we had some kind. I don't know how it will look like in the future, but of course, the judges for the position, they have tests, so they of course except of oral interview, they could be also asked to write some kind of test, or even during the interview, international experts or any other members of the advisory board may ask any question. For example, I remember then from a previous interview, because it was broadcasted, it was publicly available, so the society could had a chance to observe, to watch the procedure for interviewing, for example, of candidates. And I remember that the candidates were asked to present the case law of the European Court of Human Rights on specific issues, for instance, on criminal, the most important case law for criminal cases. So in the branch of, for example, in the context of Article 6, the right to a fair trial, or the most important cases, case law in the context of violation of Article 3, the prohibition of torture, inhuman or degrading treatment or punishment, or something like this. It could be also theoretical questions as well. So concerning the, I remember that the one of the candidates had a question, what does it mean, dura lex sed lex? It's a Latin phrase. So he was asked to interpret, to present his vision and interpretation of this phrase, dura lex sed lex. So what does it mean? And if there is a legal enshrinement or implementation of such principle in the legislation of Ukraine. So it could be, as you see, quite absolutely different questions, not only from the constitutional branch of law, but also from other branches. After the evaluation of moral qualities and evaluation of the level of competence based on the results, the advisory group conducts rating voting and forms a ranking list of the candidates. The results of the ranking vote of each member of the advisory group are open, recorded by name, and published on the official website of the Constitutional Court. Again, it's very transparent procedure. So it's an open voting. After receiving from the advisory group the list of evaluated candidates for the position, the Competition Commission, the specialized committee of the Parliament, the Council of Judges of Ukraine conduct an interview with the candidates included in the list of evaluated candidates, based on the results of which they make a decision on the recommendation for appointment to the position of a judge of the Constitutional Court of Ukraine. So, and as I said, the decisions of the advisory group can be appealed to the Supreme Court of Ukraine as a court of first instance, and the Grand Chamber of the Supreme Court as an appellate court in administrative proceedings. And as a final step, in the procedure for appointment of judges of Constitutional Court, the President of Ukraine issues a decree on the appointment of a judge on the Constitutional Court. But again, it's rather like formal step based on the results of every of the very whole evaluative process. So shortly the organizational structure of the Constitutional Court. The Constitutional Court consists of the Grand Chamber, 2 senates, and 6 boards or 6 collegiums. Now I would like to analyze or to discuss some constitutional questions dedicated to constitutional adjudication. What are the main forms of constitutional application to the court? We have three main forms of constitutional applications, namely these are a constitutional petition, a constitutional appeal, and constitutional complaint. So constitutional petition is submitted to the court as a written application for the purpose of making a decision of the court regarding the recognition of the act or its separate provisions as unconstitutional, official interpretation of the Constitution of Ukraine. And actually, these are the main 2 points if we are talking about constitutional petition. In case of constitutional appeal, it is submitted again as a written application for an opinion to the court. So it's a kind of not decision, but as a result of constitutional appeal, the court delivers opinion on the conformity of international treaties of Ukraine with the constitution, on the constitutionality of the issues that are proposed for submission to all Ukrainian referendum, on the people's initiative, and compliance with the constitutional procedure of investigation and consideration of the case on the removal of the President of Ukraine from his office by impeachment. And a very quite new instrument, it's a constitutional complaint. It was introduced in 2016 and it could be filed if all other national remedies have been exhausted. So a constitutional complaint is a written application to verify the conformity of the law of Ukraine or its separate provisions, which was applied in the final court decision with the Constitution of Ukraine in the case of the subject of the right to a constitutional complaint. And we have deadline 3 months. It is also criticized. It's a quite short deadline, but anyway, for now it is 3 months from the date of entry into force of the final court decision, which applies the law of Ukraine. So who are the subjects who can apply for constitutional complaints to constitutional court? First of all, it's individuals, so natural persons, who believes that the law of Ukraine applied in the final court decision, in his case, contradicts the constitution of Ukraine. And also it could be legal entity, with the exception of legal entities under public law. And we have 2 forms of constitutional proceedings. It's written and oral proceedings. Mostly the main form of consideration of cases, it's written proceedings. And the form of proceedings is determined by Senate and the Grand Chamber. The board, Senate, and Grand Chamber, during the preparation of the case for consideration and constitutional proceedings, in the case, may demand from state authorities and local self-government, as well as individuals, copies of documents, materials, informations related to the case. Also arrange expert examination and involve also in constitutional proceedings different specialists, experts in the field of constitutional law, also some officials, experts, and specialists, even witnesses, representatives of the subjects of appeals, citizens whose participation is necessary to ensure an objective and full consideration of the case. On issues brought before the court, Written, well-founded legal opinions, it is called amicus curiae, may be submitted to the Senate or the Grand Chamber, and the court decides at its own discretion whether to attach such opinions to the case or consider them. So these opinions of experts, different specialists, they have advisory force. So it's a kind of supplementary materials. It could be recognized, or it could be not attached directly to the specific case. And who are the participants in constitutional proceedings? Of course, the main subject of constitutional proceedings is the subject of the right to constitutional petition or constitutional appeal, constitutional complaint. So these so-called authorized persons, or it could be subjects, or as well as authorized persons acting on the behalf of the subject, for example, on the behalf of the government, on the behalf of the president, because we have the representative of the president in the constitutional court, in the representative of government, and so on. So also, of course, it's the organ or official who adopted the act, which is the subject of consideration in the court, as well as bodies, officials, witnesses, experts, translators, or any other persons involved in the court to participate in the consideration of the case, whose participation is necessary to the comprehensive consideration and adjudication of the case. So what are the rights of and duties shortly of participants in constitutional proceedings? So a participant, any of previously mentioned participant, they has a right to get acquainted with the case materials, give oral and written explanations, express their opinions on the issues under considerations, ask questions to other participants in the constitutional proceedings with the permission of the presiding judge, table motions, submit applications for recusal of a judge, exercise other rights provided by the law and the Constitution. So the term of constitutional proceedings is should not exceed 6 months. Unless otherwise established by the law. So we have for certain categories more extended term for 30 days. So as a result, after consideration, the court shall adopt decisions, provide opinions, and deliver rulings for procedural actions, as well as issue interim orders to take measures in order to secure a constitutional complaint. So these are the main forms, main types of court decisions, in general terms. So the court adopt decisions, opinions, rulings, interim orders, depending on the specific case. The court shall adopt its acts on matters not related to constitutional proceedings in the form of resolution. So if we have resolution, it means that it's not it's a decision on we could say also procedural, organizational, or administrative issues. And we have mandatory elements of the structure of the decision and opinion of the court, namely its 3 main elements: descriptive part, reasoning part, and operative or resolutive parts. Laws, other acts, or the separate provisions recognized as unconstitutional lose their validity from the date of adoption by the Constitutional Court of a decision on their unconstitutionality, unless otherwise established by the decision itself, but not earlier than the day of its adoption. And sometimes the Constitutional Court establishes a specific procedure and terms of the execution, and in the decision it prescribes, defines these procedure, as well as Constitutional Court also review the implementation, execution of such decisions. So it could also, for instance, demand from the relevant bodies a written confirmation of the implementation of decision, and so on. And on the basis of analysis of case law of the Constitutional Court of Ukraine nowadays, I could say that the main, so we have some methods of interpretation used by Constitutional Court in its jurisprudence. Namely, these are systematic, logical, grammatical, comparative, historical, and teleological or purposeful methods. And on the basis of analysis of case law, I suggest that the most applicable are systematic, logical, and purposeful interpretation. So, and the jurisprudence of the case law of the European Court of the Constitutional Court forms the so-called well-established case law. It's not like common law in Anglo-American legal family. So it's not precedent, but it is called in European doctrine well-established case law, or sometimes it is also called quasi-precedents or precedents of interpretation or application of law. So also Constitutional Court of Ukraine plays a very important role in the formation and development of national legal doctrine. For instance, in its case law, the Constitutional Court develops such doctrines as the doctrine of constitutional identity, of state sovereignty. Also, it sometimes court uses doctrines created by other international, by legal science. For instance, the doctrine of political question created in the United States of America. This doctrine sometimes also used in the argumentation of the Constitutional Court. And at the conclusion, I could say that the very functioning of the Constitutional Court could be compared with the European Court of Human Rights, and in legal doctrine we see that sometimes the Constitutional Court, it is called as a negative lawmaker or negative legislator. Sorry, do you hear me?
Yes, we can hear you.
I was interrupted by the phone. Someone called me, and this is why, unfortunately, yeah, sorry. Because somehow it is connected with my MacBook. I just want to emphasize that at least in Europe, in the role of the Constitutional Court is quite important. I know that in India you do not have such court, so the function of interpretation of Constitution is carried out by the Supreme Court. But in Europe as well as in Ukraine, it's quite, the role of Constitutional Court is quite important. And also, I recommend you, if you want to know more about the Ukrainian history, I also recommend you to watch the course of lectures by Timothy Snyder, the professor of Yale University, dedicated to the Ukraine, and this course is called Making of Modern Ukraine, and it's quite interesting. So if you're interested in just to better understanding of our background, historical background, and as well as our today's activity, so just it is free, available on YouTube. You just may watch it. So thank you for your attention. And I leave my contact. If you want to ask me in the future, maybe you can just feel free to write me. I hope it was interesting to you, and even from the perspective of possible composition of possible procedure for the appointment of the judges to the Constitutional Court, because I know it's a quite new procedure even within Europe. I'm not sure that in Germany, in France, or in in the country or of all democracy there is such a strict and transparent procedure for the appointment of judges of the Constitutional Court of Ukraine. So thank you very much, and I'm open for your questions.
Thank you very much, Kristina, Professor Trykhlib. I think this was really a very comprehensive overview of the operations of a constitutional court that certainly gathers more and more international interest these days. On my end, I particularly appreciated the kind of up-to-date nature of the presentation with respect to these changes in the selection procedure, which perhaps we can interpret in light of also the European integration ambitions of Ukraine, whereby the idea is that through this procedure there is a fulfillment of certain pre-accession criteria for Ukraine to the European Union, which of course raises a connection of to what extent maybe international organizations, international experts play a role in even such an action which is typically attributed to be in the kind of sovereign domain of the state, the selection of constitutional court judges. Now, without further ado, I would first like to open the floor to the audience. Here we also have a few participants online, so I will check again the chat, or please raise your virtual hand in Teams if you have a question, those who are online. But let's maybe have the first round from those in the room. So yes, please. So, and please try to speak up because the microphone is there. So if someone speaks in the back, you can either come to the front or I will repeat your or summarize your question.
So in class, we were discussing the institutionalist approach to judicial decision making. So I think in the context of the 2016 reforms to the Ukrainian court, I was wondering how these changes impacted institutionalism and how the institutional design kind of affects judicial decision making. Has it had the intended impact, and what are the implications of these changes? Especially you mentioned depoliticization of the court, and maybe the introduction of the advisory group and some questions of judicial independence, etc.
So maybe some trends also in the jurisprudence, whether they are visible as a result of these design changes.
And another question which is unrelated is, are the proceedings of the court in Ukrainian or in English, and or are they both, and how does that work? What is the language?
Okay, maybe can we see if there is one more question in this round? Someone who has a question in the room? Okay. If not, then yes, maybe you could address. If you have you heard the question? Was it audible?
Yeah. Mm-hmm.
Okay.
Yeah,
so
yeah.
Then
Thank you for a question. Actually, it's concerning the efficiency. If we evaluate for now, we do not satisfy with the work of Constitutional Court. I mean, in terms of number of cases adjudicated or considered, it's a quite low number in comparison. If we compare with the Constitutional Court or Supreme Court from common law in different countries. So the Constitutional Court is highly criticized by legal community, by scientific community, because of its I could not say very slow work, but the results in figures could be much more better. The first point. The second point, if we compare the level of confidence to state authorities according to different surveys conducted in Ukraine, it's paradoxically, but we see that it's a quite high level of confidence to the Constitutional Court of Ukraine. So I think that it's a good result, but it's more like that still we are waiting for the results, because unfortunately it's the reforms have been just introduced, and we cannot not evaluate the result, because as I mentioned, we are in the process of creating these advisory boards and so on. But what I see now, that I see the very strong desire. And if we're talking about formal requirements, yeah, we will see who will be how this competition will look like. I'm looking forward, and I hope for the transparent procedure as well. But also for me important the evaluation of the content of judges, so the level of reasoning, the level of arguments used in the decisions. And I see the growth, and I see that the level of argumentation constantly grows. So it is a good, it is an, I see the improvement, and I see this a very big change in the argumentation of decision, because previously it was the argumentation, honestly saying, sometimes was quite weak. And the level of professionalism, the level of competence now, it's much more higher. And I think this is a good result. It takes time, and I hope that we will see results in the future. But in terms of quality of decisions, of course, the court has improved the quality and the reasoning of decisions, case law. On the other hand, the number of cases adjudicated is unfortunately quite low. So we have this ambivalence in assessing, but I think that it's really very the start of reformation, and I hope for good results, and the society also waits for this result. There is a huge social demand for changes and for reformation, and the court now it has the confidence from society. Thank you.
And the language question, I assume the proceedings are in Ukrainian.
Yeah, in Ukrainian, but in the official website of the Constitutional Court, there is also option to English language. So we have translations of judgment into English.
Yes, and that raises, of course, the question, the broader question of the activities that a court such as the one in Ukraine may engage in to open up more broadly to the public, and especially in these circumstances also to the international public. But let's see whether we have a couple more questions also to the online participants. Please raise your hand, because this may be the last round for the online participants. Yes, please.
Yes, Professor. Thank you for your lecture. And my question pertains to something that we've been studying in class. So, as already mentioned, we've been studying the ways in which constitutional cases are adjudicated, the factors which may play a role based on which theory you subscribe to, or which theory you analyze from, and the factors that play a role in the actual process of adjudication. So my question is, in the context of Ukraine as it finds itself currently, in your opinion, would the fact that Ukraine finds itself in a state of war currently affect the manner in which the constitutional adjudication with respect to human rights specifically takes place, or is that something that formally doesn't affect the process of constitutional adjudication in Ukraine? And if it does, like how, in your opinion?
Yes, great question on the role of war, on the impact of war, and of course we have heard that during the marital law, I understand that still the court operates. The judges have to be granted independence, but let's hear a bit more on that. Any other question at this point? Let me also see online if we have someone. Not at this point, it seems. So maybe, yes, you could address, Kristina, this question of the war, because it's a very important one.
Thank you for a question. Yeah, actually, of course, we could say that war influences to the work of all organs, including Constitutional Court. But I see that the Constitutional Court functions, it operates, and I can't say that the war. So if we compare, for example, the statistics before war and after, actually there is no difference in figures, in numbers of cases considered. Yeah, so it's the first point. The second point, of course, the Constitutional Court nowadays tries to focus on the issues of the national security. So we could say, in terms of adjudication, in terms of content of decisions, of course, the focus shifted to the preservation, observance of the national security, and all other issues, all other cases, they are considered through this prism. So we have this very strong demand for the preservation of our social sovereignty and national security. And of course, I think that the war influences the adjudication, and the accents, they are shifted, and it is also, it could be seen in the reasoning of the decisions. Concerning the human rights, of course, the Constitutional Court, we have the constitutional complaint, as I said, and our citizens, they continue to file constitutional complaints through the Constitutional Court in order to protect human rights. And we have also online procedures, court procedures, provided in our law. So it is possible also some proceedings, for court proceedings, to be held online. And it somehow, it also facilitates the access to justice to the court as well. And Constitutional Court considers constitutional complaints and tries to protect human rights. Especially now, I see the emphasis to the social rights, to the special protection of socially vulnerable groups of society who cannot protect, objectively cannot protect themselves. And the Constitutional Court also gives this additional support, additional protection to social rights, and this I see. And also I see strong communication, collaboration with Parliament. So it's also very important, because we, unfortunately, there is no binding procedure for the implementation of judgments of the Constitutional Court. So shortly saying, there is no procedure prescribed for the violation of or non-implementation of judgments. And now I see, previously in our history, we had different situations when, for example, a parliament tried to not implement the judgments of the Constitutional Court, and we have such blocked situation on a specific. But now I see the very strong collaboration with Parliament, and Parliament reacts very quickly on the decisions, on the demands of society, and try to implement the requirements and the decisions of the Constitutional Court very quickly. And this is a good also signal for society, especially in the context, as I mentioned, in the context of social rights. Concerning the human rights, for example, violated during the war, I don't see for now such tendency for filing constitutional complaints on the, for example, human rights restriction because of war, because I see in our society that everybody understands that in martial times human rights may be restricted. Of course, the question also will be the proportion of these restrictions, the legitimacy, and the margins interfere human rights by state. But for now, because my international colleagues also asked me about the separation of powers and the restriction, limitation of human rights in times of war, I see, of course, according to the law of Ukraine on martial law, some human rights, they are restricted because of martial law, because of war. Very similar situation we had during the COVID-19. So nowadays we have the same, but more, I would say, even more stricter. So I see that there is no such, complaints application concerning the restriction on human rights because of this martial law. So there is no such concern in society, but we have emphasis in constitutional case law on social rights and and the interest of national security, territorial integrity, and national sovereignty. Thank you.
Yes, thank you very much. And perhaps this growing emphasis on social rights as well as collaboration with the legislature also indicates a democratization, a growing democratization process in the regime, because it's a sign of advanced democracies that constitutional institutions collaborate, that there is dialogue, and there is also respect towards authority of the court judgments, and also a more robust reading of human rights. At least that would be the traditional reading of how advanced democracies operate. Are there any last questions to our speaker today? Okay, I don't see any at this stage, so maybe if you allow me, I have one. Well, I have actually many questions, but maybe I would just ask one, which I think is particularly possibly interesting to this audience in terms of decolonizing, perhaps I would call it, the jurisprudence of the Ukraine Constitutional Court, because in your article, I don't think you mentioned in the talk, because of course the article provides a lot of additional ideas, which I recommend again everyone to read that piece. You mentioned this influence, this dark influence of the Soviet legal thinking on the Ukrainian Constitutional Court, particularly during the period when also Ukraine was not necessarily a democratic regime, but there were also lots of authoritarian tendencies. And so how, in a sense, the Constitutional Court now perhaps tries to get rid of that legacy, or kind of decolonize, perhaps we could say, its jurisprudence from these influences of the Soviet legal thinking that is mainly not a democratic form of legal thinking, because it has evolved in the Soviet Union, which has been an authoritarian regime. So if you see any trends, if you have any insights, particularly recent ones, because the article is from a few years ago, I think that would be very interesting also for this discussion that we have here on path dependencies. We have discussed in the course on the role of legal ideas as translating to the impact of decisions. So perhaps that question, and unless I miss someone online with an urgent question, then I think,
Thank you, Max, for a brilliant question. Actually, I believe, I don't know, I think that there is no one right answer on this question. So every country has a unique step and unique, I don't know, history. And what I see nowadays in Ukraine, of course, I see the improvement of the reasoning of decisions, and I see the improvement of scientific argumentation. And that is why I think there's a very important point here in the composition of the Constitutional Court of Ukraine. I think that now we have more scientists, more not only judges, not only practical lawyers, but also scientists. And I think that scientists, they actually strengthen the Constitutional Court. And I think these scientists, they are the main subjects of changes in terms of adjudication and in terms of implementation of these Western principles, values of human rights, democracy, rule of law, freedom, and so on. Because actually, these main values, they must be integrated, they must be implemented in legal norms. And we have the problem that still in Ukraine prevails, unfortunately, the so-called positivistic approach to law. I see this tendency in court decisions, not by the Constitutional Court, but by other courts, by district courts, by lower courts, first of all. And I see this positivistic approach. I realized that probably it is because the legal science was absolutely different in times of Soviet occupation. And these practical lawyers, judges, prosecutors who works at their posts, they have not studied modern Western legal theory, constitutional law, and legal science in general. They were limited to ideology, communistic ideology, and communistic views, positivistic views to law. And after the collapse of the USSR, there was no retraining. So there were different steps implemented in order to improve and to how to integrate ex-Soviet countries into European legal understanding, legal community, legal values, and legal the common European legal perception of law. But again, it was quite problematic, especially in Ukraine. If we are talking about Ukraine, we were over 70 years or even more from 1917 under Soviet occupation. It means that it's 2 or even more generations of people educated, behaved in very strict ideological context, including higher legal education. And education is a key for success and for proper understanding. And I see sometimes that even if some principles such as rule of law, democracy are enshrined in written acts, in constitution, in laws, they are not implemented in practice by different public authorities and public officials because they simply do not understand the meaning, very essence of these principles and how these principles could be implemented in specific case. And the same situation I see in the judgments of different courts of Ukraine when they just refer to the principle of rule of law without indication of its application into this specific case. So how the rule of law, what requirements of rule of law were implemented in this specific case. There is no right understanding and there is no actually explanation of the application of rule of law in every specific case. And all this because of the lack of knowledge, because of the lack of education, I think. And that is why actually concerning the Constitutional Court, I see changes. I see very good changes because, as I said, through the composition of the Constitutional Court, many scientists nowadays, at least, scientists, they have joined the Constitutional Court and they have strengthened the reasoning by the Constitutional Court. And I see not only just the Constitutional, but the Supreme Court as well, because we had also from 2016, after the Revolution of Dignity, we started the very big reformation of Supreme Court of Ukraine, and it was also the composition of the Supreme Court was also strengthened by the scientists, and after after this, I see the improvement of quality of decisions by Supreme Court as well as by Constitutional Court. So I think that the main the key for success here is education. Education, and again, I see that we have more scientists and the quality of decisions much more better. But again, it takes time. It takes time. I don't know what about other countries. Maybe they have their own. I don't know. Of course, they have their own problems, but I feel that in Ukraine we have to involve more scientific, more education in every state authorities, especially in Constitutional Court.
Perfect. So coming back to history with your reference to Timothy Snyder and the making of modern Ukraine, so lawyers also need to understand history and the background of the legal systems that they are embedded in, and ultimately, of course, a holistic approach to education. Thank you so much, Professor Trykhlib, for this very illuminating talk and the discussion, also to everybody who has participated, and for your questions. So I hope we can follow up in these discussions also further in the project, but also observe the development of the Ukrainian case, which is really one of those extremely understudied. I have the impression, I just checked the Google Scholar before the talk, and very few sources. So one of those which are available is, of course, your work, and hopefully there will be more of those coming up. So thank you so much. Maybe we can give one more round of applause before we go. Have a nice rest of the day and weekend.
Thank you very much. It was a pleasure to be with you. I wish you safe and healthy weekend, and see you on other events. Thank you very much. Bye bye.
Thanks a lot.